A very good afternoon to all my dear students. Good afternoon, Kunal, Bindya. Yes, Kunal, definitely we will be doing examination questions today. I remember we discussed last time, so don't worry. Sandeep, Padula Parthi, all those who have joined the class, a very warm welcome to all of you children. So it's the last class of partnership today, and we'll be completing Unit 3. And as promised, we'll also be doing certain examination questions that have recently come up from the partnership. So I hope you have revised the part that we have discussed in the last class. We have already completed registration of firm. We also did a question from the module related to that. So let's have a quick recap of registration. Section 58 tells us the statement which is to be filed with the registrar of firm. So I told you, one is the register in which you have to make an entry. Who makes this entry? The registrar of firms, the concerned person who is sitting at the registrar of firms will make this entry. So first, if there are three partners, Mr. A, B, and C. So A, B, and C have decided to open up a partnership firm, and they know that it is better to get the firm registered so that they can enjoy the benefits and advantages of the registered firm. So they have to go, suppose they're opening the office in New Delhi. So they will have to go to the New Delhi ROF, that is Registrar of Firms, and get themselves registered. So they will tell that the name of the firm is ABC Associates. They are opening up the office where in New Delhi, Connaught Place, or wherever you have decided. What place where the business will be carried out. So one can be a head office, one can be a branch office. On the date when the partners are joining, full name, address, and duration of partnership also be discussed. If the partnership duration is given, it is fixed partnership. If it is not given, then it is partnership at will. After that, section 59, when the registrar is satisfied that the provisions of section 58 have been complied with, means you have filed all the statement correctly, then he will record an entry. So this is the register of firms, a normal register in which you make your notes. Similar registers are kept over there, and they will make an entry ABC Associates. So when this entry is made, the process is completed, the statement has been filed, then a statement of registration is, certificate of registration is issued to the firm. So now my question to the class is, if the firm, so registration of firm is not a compulsory process, we all remember that. Good afternoon, Sarla, Akshita, all those who have just joined the class. Good afternoon, Riddhi, Ravi Kumar, Preeti, everyone, welcome to the class. So if it is optional, then why it is important to get the firm registered? Good afternoon, Prabhat. Why it is important? So there are 4 consequences of non-registration of firm. So if I ask you what are the advantages of registration, then you will write in a positive sense that a firm can file a suit or partners can file a suit. But if I'm asking, yes, Bindya, I'm correcting you on that. So if I'm asking you what are the consequences of non-registration, then you have to tell them that if the firm is not registered, no partner can file a suit against each other. वो legal language जो हम आपको हर बार बताते हैं ना बेटा, यहाँ पे legal language plays a very, very important role. So you have to tell all these points correctly, that no suit can be filed either by the firm or by the co-partners against the third party. No relief is given to the partners for set-off and claim. What is the exception over here? Up to ₹100, you can claim the set. Aggrieved partners can also not file action against each other. However, third party can always sue the firm, whether you are a registered firm or not. Clear? And then if any partner has died, you don't need a fresh certification if you were a registered firm. But if any partner has joined the firm, then you always need to have the name of the partner in the certificate of registration. Then all these MCQs we have done. So we have started section 39 in the previous class. where I told you what happened when the firm is getting dissolved. If the firm is getting dissolved, let's quickly do the differences between dissolution of firm and dissolution of partnership. So one is that the firm is discontinuing its business, means they will no longer do the business. So there were three partners who have joined and now their relationship has ended, whole of the firm gets dissolved. So it is complete binding up, means complete closure of the firm. All the assets are realized and liabilities are paid. This may happen by the court's order also. It involves dissolution of partnership and it is final closure of books. So how it happens today under section 44, we will understand how the court orders for the dissolution of firm. Whereas in case of dissolution of partnership, only the constitution of the firm is changing. That is, a partner is joining or the partner is leaving. And reconstitution is happening. Revaluation of assets and liabilities will be done. All right, children. So let's start with the modes of dissolution. What are the various types of modes how the firm is dissolved? Section 40 to 43 talks about without the order of court, and section 44 exclusively tells you where the court will pass the order that yes, the firm needs to be dissolved. So there are 5 types of dissolution. Now, examiner can give you a straight away question for 5 marks. What are the various modes of dissolution? In that, all these points have to be given and briefly you have to explain them because it's a 5 marks question. So you don't write long stories because section 44 is very big, children. Today we'll do it. But then you have to briefly give the points. But if I ask you for 5 marks, explain the procedure of dissolution by court only, then you elaborate all these points. Okay, bacha? अक्षिता इज आस्किंग मैम, अगर 2 लोग पार्टनरशिप में है और 2 पार्टनर पार्टनरशिप खत्म करना चाहते हैं पर फर्स्ट नहीं चाहते, so Akshita, that is what we are going to understand today, that how does the dissolution happens. If it is partnership at will, then yes, one of the person can also give a notice, it will come to an end. But in other cases, we will discuss one by one how the partnership can come into an end. All right, and for the previous one, Sandeep, Bindya, Prabhat, all of your answers are correct. Pooja Yadav. Okay, very good. Yes. So section 40, the first section which tells us that dissolution can happen by an agreement. So the firm may be dissolved with the consent of all the partners if there is a contract between them. So we decided ABC Associates will continue the partnership for 5 years. So हमारा partnership deed में हमने लिखा हुआ है that it is a fixed partnership. So 5 years के बाद the contract will come to an end. Okay. Also, it can be inferred from the circumstances that when the closure of business and final accounts are being closed, then the firm will come to an end. Dissolution will happen by agreement. Means हमने कॉन्ट्रैक्ट में ही लिख दिया या फिर हमने ये लिख दिया कि 1 अक्टूबर को हमने बनाया पार्टनरशिप अरेंजमेंट और कहा कि 31 दिसंबर को ये पार्टनरशिप खत्म हो जाएगी, मतलब एग्रीमेंट में ही वी हैव रिटन, कॉन्ट्रैक्ट के ऊपर डिपेंड. सो दैट इज द सिंपलेस्ट काइंड ऑफ dissolution by the agreement. Next, very important dissolution is compulsory dissolution. Happening of an event which will make the business unlawful or the partnership unlawful. Means something has happened due to which my business has become unlawful. Let's assume an example where the firm is carrying on the business of trading in a particular chemical. And a law has been passed which says that there is a ban on this particular chemical. तो एक chemist का हमारा business है, partnership है, and we have ordered from the dealer a particular type of chemical, and now it has been banned by the government. So अब government ने अगर ban कर दिया तो legally वो business अब unlawful हो जाएगा. You cannot do the same kind of business. Now the business has become unlawful. So the firm will get compulsorily dissolved. Means अब उस फॉर्म को चलाना मुमकिन नहीं है. You have to dissolve the firm. So section 41 clearly talks about the happening of an event in which we have to dissolve the firm. Okay. Just open the module also once. I'll show you these 2 points from the module also once, and then we will continue further. Yes. So after registration, we did all these points, and this case study is very, very important. Example 1, which we have discussed earlier also and revised now. So we can expect a similar kind of question, children, in exam also, because it is a kind of a case study. So dissolution by firm are the cases in which we have started. So first is section 40. We have already discussed the contract between the partners, and for the compulsory reasons, whenever there is an illegal cause, then we have to dissolve the firm. All right. So I can see ma'am is also here with us. Good afternoon, ma'am.
Good afternoon, Harleen. Yes, I want to interact with the students for some 10 to 15 minutes, if you allow me.
Yes, ma'am, surely. So ma'am will address your certain queries, students. All right, ma'am.
Yes. Good afternoon, dear students. As you are aware that today we will complete Unit 3 of the Chapter 4, that is Indian Partnership Act 1932. Okay. So the notes and assignment I will share by after the class positively. Please refer the questions given in the PPT and complete the questions from the study material as well as the entire chapter from the study material by today itself, because we are left with now 3 more chapters, that is the LLP Act, Companies Act and Negotiable Instrument Act. And if you have seen the schedule, you will find that from Friday onwards, we are having continuing class till Monday. On Friday, we have a LLP class. Then on Saturday, please note down that we have a different time for that class, that is from 10 to 11, from 11 to 1 in the morning, we have a class on the Companies Act on Saturday. Then Sunday, again, we have a class of the Companies Act from 2 to 4 and Monday. So Friday, Saturday, Sunday, Monday, we have a continuous class. So please continue with attending the LVC class and start revising, start reading from the study material simultaneously. Otherwise, you will not be able to complete the course within the tenure. As you are aware that by 3rd August, I can assume you may be noted that only 10 days time is left to complete the LVC. By 3rd August, we will complete all the chapters of the study material in our LVC. So you have to increase your pace. Okay, just complete the study material by 3rd of August, or hardly or 1 or 2 days you can take extra. Okay, after that, after 3rd August, from 4th August, we are having continuous webinar. So you have to gear up. As we are gearing up our LVC faculties, we are conducted day-wise webinars, day-wise classes for you, so that your course can be finished on time. And approx from 10th August to 15th September, 1 month will be given to you so that you can study easily. You can study at home without any distraction. Okay, so our entire syllabus will be completed by 3rd August, and after that, within a 1 week, we will complete the webinars also. So please complete the study material well in time so that you can raise your doubts in the webinars. Okay, after that, as soon as you complete the webinars, we have organized the MTPs for you. Okay, MTPs are the model test papers, the sample papers which are being asked in your examination. The same type of pattern, same pattern of questions, KNC, A&A, and number of marks, 20 marks ka each question. The same pattern will follow in your MTP. So you have to give the MTP first and 2 series compulsorily. It is mandatory for all your benefit. It is not mandatory as such, but it is beneficial for you. You can go in your nearest branch also. Otherwise, if you don't want to waste your time in going the branch and give the paper, you can download the MTP at 2 p.m. the same day, the date 2 p.m. the question paper will be uploaded, and after 2 days you are given 2 days time for completing the paper. Okay, but do not take this as an opportunity. Try to do the paper at 2, just start the question paper at 2 p.m. Okay, and try to finish the sample paper, the model test paper, mock test paper within 2.5 hours. I earlier told you that maintain a target of lesser time. If you try to complete the paper in 3 hours, then under the examination conditions, when you are giving your paper on 18 September, it will be very difficult for you to complete the entire paper. Today also I received a query that, ma'am, she was asking that, ma'am, I have given my paper in May 2025. If the student has joined, she will understand. I cannot recognize, I am not remembering the name of the student, but she was telling that I was not able to complete my question paper in 3 hours time. Okay, so these type of common issues the students are facing. So always after 10th August, just try to do so many sample paper. When you were in 11th or 12th also, when you were given board paper, you have attempted the sample paper now. So same sample paper 10 model test booklet we have provided, which contains 10 model test papers. You should try all of them. Okay. If anybody student is having any query, they can raise to me. Arjun, please write in the chat box. Manjusha, please write in the chat box. Yes, Shri Krishna is asking, मैम लास्ट के एक मंथ में MTP करे तो आपका देखो लास्ट का एक ही मंथ है। जो भी नाम था बच्चे का, क्या नाम था, श्री कृष्णा, आपके 10th अगस्त के बाद ही वी आर कंडक्टिंग द MTP, सो ओनली 1 month इज टाइम इज लेफ्ट। ओके, सो 1 month में आपको 2 MTPs करने हैं, और along with 10 model test papers already uploaded on the website. Okay. रचना इज आस्किंग, मैम MTP का रिजल्ट कितने दिन में आता है बेटा? अगर इफ यू आर गोइंग इन द ब्रांच, then the result will be checked by the answer sheet will be checked by branch, but I am not sure how much time they take. But if you are going to do the MTP at home only, you after 48 hours the answers will be published, so you can compare your answer with the answers given by me. Okay, we will upload the answers after 48 hours. So you can compare your answers with the answers provided by the BOS and compare yourself. Do not depend on anyone. Okay, I always use this line that you are the judge of your own. Do not depend on anyone that this person will help me, this one of my friend will help you. Yes, obviously your parents will guide you, your mentors, BOS faculties, LVC faculties will guide you, but do not depend on anyone else. Okay, just check your answers and analyze in which portion you are getting less marks. Okay, so if this type you can compare your answer. नहीं मैम, मैं वो MTP बुकलेट के बारे में बात कर रहा था। MTP बुकलेट बेटा इज ऑलरेडी अपलोडेड। हाँ, आप वो 1 month में उसको डेली बेसिस पे, जैसे आपके पास अभी मेरे पास एक क्वेरी भी थी कि व्हाट विल बी द टाइम टेबल ऑफ लास्ट 1 month। ओके, आपका 10th अगस्त को वेबिनार कंप्लीट हो जाएगा, 11th से लेके आपके 14th अगस्त तक MTPs हैं, आप MTPs दीजिए। बट साइमल्टेनियसली आपको क्या करना है, यू आर हैविंग ओनली 1 month टाइम, तो जस्ट ब्रेक द टाइम half, you just break time 1 month within four slots. First week you have completed the study material, है ना? तो in the first week after 10th August, just try to take 2 papers at a one time. Either when I was the student, I take 2 papers, one theoretical, one practical. Theoretical in the morning and practical in the evening. You can decide as per your choice. Okay, 2 papers, just within a week revise. I am not saying reading. I am assuming that you have all completed the study material by 10th August. Okay, and you can raise your doubts in the webinars itself. Okay, after 10th August, just take one week, make a timetable that yes, I have to complete the study material within 1 week time, either law or one theoretical plus practical paper. You can take maths also, you can take accounting also, because general economics and law are theoretical papers. So you can make combinations of your own. Okay, and then second week, last remaining 2 papers, complete the study material. So within 15 days, you have completed and revised all the 4 papers from the study material. Okay, then in the next 15 days, you just simultaneously revise the study material and practice the questions. Daily, you have to do 2 sample papers. 2 papers are there, 2 sample papers. It will take 5 hours. Okay, so within 15 days, you have to attempt minimum 10 to 11 sample papers of all the papers, whether it is accounting, whether it is law, whether it is general economics, whether it is quantitative aptitude. 10 papers is being given in your website. Okay, so 10 to 11 sample papers as well as suggested answers are there. 4 to 5 suggested answers are there. So in the last 15 days, you have to daily do the sample papers, model test papers. Okay, and simultaneously revise from the study material, because minimum 3 to 4 times you have to revise the study material. Only then you will be able to clear the papers. Yes, Rachna is asking, ma'am, MTP solve just MTP solve करते टाइम हम all 6 क्वेश्चन सॉल्व करें या 5? Yes, this is a very important question. आप सारे क्वेश्चन सॉल्व करो, बट अगर आप सारे क्वेश्चन कर रहे हो तो टेक द टारगेट ऑफ 3 hours. I was talking about 5 questions. Okay, but 6 क्वेश्चन भी आप अटेम्प्ट करो और अपना टाइमर 3 hours लेके चलो. इससे क्या होगा, मे बी इफ यू हैव नॉट अटेम्प्टेड द 6 क्वेश्चन और वही आपका पेपर में आ गया, तो इट विल बी लॉस फॉर यू. Okay, attempt all the 6 questions of the NTP in your home, but not at the examination center. Examination center may you have to do only 5 questions. Okay, yes. One query I received in the morning, he was asking that, ma'am, he was shown some screenshot. Ma'am, I have diagram. He has represented one case study in the diagram, and he was asking, ma'am, I can draw the diagram and answer accordingly. I said no. In the CA examination, no diagram, no flow charts, and no WhatsApp language is required. You cannot write. You have to write the whole answers in paragraphs, different bulletins. Okay, so no diagrammatic presentation, no flow charts is accepted. It's acceptable in your examination. Okay, one query. Second query, he was asking that, ma'am, how can we write in our in bookish language? The book language is little bit difficult for the students. Yes, I accept, but how can I write reproduction? I am not saying, we are not saying that you write as it is. You can write in your language. I repeat in the in the previous class also that you can write in your own language, but that language should be legal. Okay, legal language क्या होता है कि जो भी आप provision लिख रहे हो, whatever provision you are saying, you are writing, that should be correct. Grammatical mistakes चलेगी, but एक कल बच्चे ने मुझे एक आंसर भेजा that contains so many spelling mistakes. It should be avoided. Spelling mistakes नहीं चाहिए, जैसे considered की spelling, partnership की spelling. आपके इस he has written Sony, one person named Sony, Tony, Moni and Sony. Sony का नाम आपका क्वेश्चन में लिखा है SONY and he is writing SONEY. So these type of mistakes please avoid. Okay, we are not saying that you write in proper English, but whatever you are writing, that should be correct, spelling correct, legible writing. Okay, yes, 2-3 chats I received. Pranav is asking, मैम लॉ में डायरेक्ट क्वेश्चन कैसे लिखें, उसमें प्रोविजन लिखना जरूरी है? यस, डायरेक्ट क्वेश्चन हो या एप्लीकेशन ओरिएंटेड क्वेश्चन हो, यू हैव टू राइट द लीगल प्रोविजन. It is compulsory. Step-wise marking is there in law paper. Okay, so you have to write. Direct question में क्या होता है, आपका theoretical question है direct. So you can write the legal provision. If the question involves differentiation, so you can. Yesterday I received a query that, ma'am, whether we can write in the tabular format. Why not? You can write. Tabular format is given in the book also, so you can write in proper tabular format. If the you want to write in different paragraphs, you can write in different paragraphs, different bullets. Okay. मैम आंसर में प्रोविजन, तमन्ना इज आस्किंग, मैम आंसर में प्रोविजंस पॉइंट्स में लिख सकते हैं क्या? बेटा प्रोविजन आप लिखो, कोशिश करो कि आप उसको पैराग्राफ में ही लिखो, बट इफ यू वांट टू बाइफरकेट द प्रोविजन यू कैन ऑल्सो डू दैट. ओके, बट आप ये देख लेना और एंड कॉमा, क्योंकि लॉ में इंटरप्रिटेशन और का अगर आपने एंड लिख दिया या एंड का और लिख दिया तो इट इज अपोजिट. ओके, इट चेंज द मीनिंग. Palak is writing, ma'am, if I skip one attempt without paying examination fees, then it will reduce my attempt or not. I think your registration is valid for 5 years, so it's up to you. But please confirm from the examination. Okay, you want to skip, you can skip, but the foundation your registration is valid for 5 years. After that, you have to revalidate it. श्री कृष्णा इज राइटिंग, मैम आप हो कहाँ पे, डाउट भेजना है बेटा. आई एम सीइंग योर डाउट. पहले भी मैंने आपका डाउट लिया था. अगर आपको कोई भी और डाउट्स होते हैं तो यू कैन डाउनलोड द BOS मोबाइल ऐप एंड देयर इज अ पोर्टल आस्क योर क्वेरी. डेली वी आर रिसीविंग, आई एम रिसीविंग सो मेनी क्वेरीज and I am daily replying to all of you. Okay, so you can send me. Yes. One query, study material revision हमने देख लिया कि minimum 2-3 times you have to revise the study material. Okay. Timetable we have done. Yes. Some student was asking कि ma'am how to prepare notes. Beta, if you want to prepare notes, you can prepare. But according to me, if you ask me, there is no need to prepare notes. You can simply underline the important headings, important points in the study material, and for notes purpose, you can refer the saransh. है ना? आपने कितने सारे students are referring, they are daily asking me queries from the saransh. They are daily calling me कि yes ma'am, this point is very good, इसमें problem है. तो saransh you can refer because saransh is the notes only. Okay, तो सारांश में आपका every chapter we have provided in the notes, and if you want to there are one set of notes extra, that is our LVC notes. We are constantly uploading on the website. Our faculty has prepared and we are uploading. So notes you can refer of the LVC also. Okay, so I think there is no need to maintain extra notes because it will be a time consuming task. प्रणव इज आस्किंग, मैम लॉ में स्टडी मटेरियल में जो आंसर है वो केस स्टडी में लिखना जरूरी है कि अपनी लैंग्वेज? बेटा देखो, अभी मैंने ये क्वेरी ली है आपकी कि अपनी लैंग्वेज में लिखने की, आप अपनी लैंग्वेज में लिखिए. लीगल लैंग्वेज की कोई जरूरत नहीं है. लीगल लैंग्वेज होनी चाहिए बट एज ए बुकिश लैंग्वेज वी कैन नॉट एक्सपेक्ट. आप अपनी लैंग्वेज में लिखिए बेटा. Rachna, you can download the BOS mobile app. There is a portal, ask your query. Okay, so you can contact me with that number. श्री कृष्णा इज आस्किंग, मैम हमने तो बना लिए हैं नोट्स. वेरी गुड. जिसने बना लिए हैं बना लो, जिसको बनाने हैं दे कैन ऑल्सो मेक नोट्स. बट अगर आपने अभी नहीं बनाए हैं तो यू कैन रेफर द सारांश ऑल्सो. Okay, so I have taken all the queries which I was receiving from yesterday. Yes, 6 webinars will be there. After that, I have told you that just attend the 2 MTPs and I will meet you on Friday. Okay, so Friday, Saturday, Sunday, Monday, we have a class for 4 days consecutively. So please attend the same and ask your query. Yes. Harleen, you can take over the session.
Yes,
Meanwhile, I
thank
will
you so
reply through
much,
chat.
ma'am.
Okay, thank
Thank
you.
you, ma'am, for addressing the queries of the students, and
Thank you.
they always feel happy in interacting with you. And I
Yes.
hope they are satisfied now. Further, we can move and take the
Hopefully.
class.
Yes.
Yes, yes. All right. So, yes, students, welcome back. So, I hope you have asked your queries, and now let's get back to the session and we'll continue dissolution. And then, students, I have number of case studies and questions also for you today. You will get the assignment, ma'am, they will get the presentation today. I
Yes.
think we should study for one day and then we'll give them the assignment by tomorrow so that they can just go through the topic parts.
Yes,
So maybe
yes.
by
We'll
tomorrow,
definitely upload
yes.
them.
So by tomorrow you'll get the assignment also. All right. So
PPT you will get by evening, and assignment we will provide you by tomorrow.
yes, yes. So you all have to study very well. We have already completed unit 1 and 2 also. And these students, as ma'am also advised you, we all really want, because you're putting so much hard work, you're attending all the sessions regularly. So if you really want to clear your exams, continuously be consistent with your efforts and keep revising whatever we have done so far. And today, when we complete unit 3, just go through all the notes and revise this chapter also. It's a very small chapter, but today when I'll discuss with you previous examination question paper, 20 to 24 marks paper came from this very chapter. So it is very spory also if by luck you get the similar kind of questions, because you cannot say that same questions will come again or not. But if you have done the chapter thoroughly, then you can also get good marks from that. Now, section 42 talks about subject to the contract between the parties. So first, this line, what does this line mean? That with respect to whatever contract which we are having between the partners, if we are having a separate contract, then we will follow that particular contract. But if there is no separate contract with respect to these 4 matters, then when the partnership is formed for a fixed term, that is a fixed partnership, will come to an end on the expiry of that term. And if it is a particular partnership, it will come to an end once the adventure or particular venture is over. In case of a death of a partner, it says unless contrary. On the death, most likely, ordinarily, we have read also this thing, that the partnership will come to an end. But if you have agreed contrary, that yes, we will still continue, then you can continue with the partnership. When the partner is adjudged insolvent, insolvent means now he is no longer able to pay off the debts and liabilities, so the partnership will also come to an end. So contingencies means uncertainties, something which is happening which is not sure. But if you'll see, the first 2 points is not exactly a contingency, because that is the term when the partnership is ending. That is the particular partnership when it is ending. All right. But in case the partner has died, a contingency has occurred, then if the contract says yes, then yes, the contract, it will come to an end. And if the partner is adjudged insolvent, then also. So what you have to learn over here: fixed partnership, particular partnership, death of a partner, insolvency. These are the 4 cases of section 42. Then section 43 is another very simple section. It talks about dissolution by notice in case of partnership at will. So if A and B has decided to open up a partnership without deciding the term and no determination of partnership, then it is partnership at will. Now, A sends a notice in writing to B that I don't want to continue this partnership. So any partner can communicate by sending a written notice, and the date of dissolution will be the date which is given in the notice, and if no date is given, then the date of communication. Suppose A writes to B on 1st January 25 that I want to end this partnership from 10th January 2025. Then what is the date when the partnership will get dissolved? Yes, Rachana, then remaining partners can definitely continue the partnership. There is no harm in that. We will have a case study also on this question today. Yes, Bhanu. No, Bhanu, you're wrong. Why did you say 1st January 25? So when I have written the date that it is 10th January 25, then the partnership at will come to an end on 10th January. Suppose A writes a notice on 1st January, but it does not give any date. Then from the 1st January 2025, the partnership will get dissolved. All right. And now come the cases of Section 44, partnership getting dissolved by court. Somebody was writing in the query, ma'am, how will court come to know about the dissolution? So when case number 1, a partner becomes unsound. There are 3 partners, A, B, and C. You will read the line in the study material. When one of the partners becomes unsound mind, the other partners can file a suit for the dissolution to the court. Somebody will have to go and intimate the court. Court will not get a dream that there are so many partnerships running up, somebody has, some problem has occurred. So person who is filing a case will go to the court and tell them that one of the partner has been declared, other than the partner who has been declared unsound. Now here comes the picture where we actually have to read the law, which I call reading between the lines, so that you understand how we actually have to interpret them. So these were the 4 cases of contingency. Notice ka ho gaya. So insanity or unsound mind. With a partner, not a sleeping partner. तो कहते हैं sleeping partner को तो ये applicable ही नहीं है. Nikhil and Anika, I will give you time to speak. Let me just complete section 44 first, okay? So when a partner who is not a sleeping partner has become unsound mind, then the court will dissolve on a suit of the other partners or by the friend of the insane partner. He can also file a case that this partner has now become insane, means mad. He is not no longer having his mind to work. Then court can declare dissolution. कोर्ट में एट द सूट ऑफ द पार्टनर, प्लीज रिमेंबर, जब पार्टनर केस फाइल करता है तब इन फॉलोइंग ग्राउंड्स के ऊपर किसी भी वजह से कोर्ट फर्म को डिसॉल्व कर सकता है. कब करेगा? जब सूट फाइल्ड बाय द पार्टनर, मींस व्हेन वन पार्टनर फाइल्स अ केस that we want to get the firm dissolved, then court will order the dissolution in the following cases. But temporary sickness is no ground of dissolution. किसी पार्टनर को टाइफाइड हो गया, इन्फेक्शन हो गई, कोविड हो गया, तब थोड़ी ना आप फॉर्म डिसॉल्व कर दो. He was not able to conduct the business for few weeks. This kind of illness is not a ground for the dissolution. ऐसे तो फिर हर पार्टनर बोलेंगे कि मेरा पार्टनर बीमार है, he is not coming, he is not well prepared, so any problem is happening, then shall we dissolve the firm? Then law says then it is not allowed. You have to have a valid reason of unsound mind or insanity. There were 3 partners, A, B, C. Mr. A was under the influence of occasional drinks. So you must have read under Indian Contract Act, somebody who is occasionally of unsound mind but regularly of sound mind. Say, for example, when you're under the influence of alcohol. So can B and C file a case that this person has now become unsound mind? Is it a valid ground? Tell me. No, ma'am, they cannot. Very good. All right. Yes, Prabhat, I know that you typed the question. I hope now your answer to that question is clear. And yes, Bindya, Bhanu, Kunal, everybody, correct answer. They cannot find. Yes, because most of the time he's of sound mind. You cannot have a reason, such kind of reason for filing a court for the dissolution. Then comes into picture permanent incapacity. When the partner, other than the partner suing, means जो partner case file करे, A, B, C. So A को permanently incapacity होगी. Some accident occurred with him and he's permanently incapable of doing his duties. Once some part of his body has become, you can say that it is not stable. He cannot move properly, or legs have become permanently incapable of walking, or any such kind of thing has happened. Then other than the partner suing A को ये हुआ, तो B and C case filed where the partner has become, other than the partner suing means B and C are filing a case. One of the partner has become permanently incapable. Then also the court will order the dissolution. Permanent incapacity will result from the physical disability or illness. कोई partner कोमा में चला गया, बीमार हो गया, कुछ काम करने लायक नहीं है, तो फिर resolution by court हो सकता है. Next is the case of misconduct. Misconduct का मतलब क्या होता है? Misbehavior. You're not conducting your services properly. Misconduct means any kind of guilty of misconduct where the partner, other than the partner suing, is guilty of conduct and carrying on the business, then the court will order the dissolution. It is not necessary that misconduct is related to the business. Important is if it is adversely affecting the business. In each case of business, it is important to decide an act of misconduct. So there are three partners. One of them misbehaves with the staff in the office or tries to mistreat anyone in the office. All right. So this kind of habits, if you're having, or some wrong things that you're doing, then it can be a misconduct, misbehavior, or you're trying to do any kind of wrong with the clients of the partnership business. Then also the firm can be getting dissolved. Persistent breach of agreement. Regularly the agreement is being breached means, persistent means continuously. Breach means धोखा देना, agreement को break करना, तोड़ देना. आपने एग्रीमेंट करा कि मिस्टर ए बी सी में से जो ए पार्टनर है वो 10,000 से ज्यादा परचेजेस नहीं करेगा, वो बार बार 15,000 की कर रहा है, बार बार अपनी एग्रीमेंट को तोड़ रहा है, एम्बेजलमेंट कर रहा है, कैश के साथ हेरफेर कर रहा है, एरनेस अकाउंट्स, परचेजेस की एंट्री सेल्स बुक में डाल रहा है, अकाउंट्स गलत दिखा रहा है, holding more than the cash allowed. If you were allowed to hold only 1 lakh rupees in cash, you're holding 10 lakh. Refusal to show the accounts. All these are the reasons of breach of agreement. Then the other partners will go and file a case and the court may dissolve the firm. If one of the partners is keeping erroneous accounts and omits to enter the receipts, or there is a continuous quarrel between the partners, लड़ाई झगड़ा हो रहा है partners में, I told you day one, partnership is all about trust, faith and confidence. अगर partners को एक दूसरे के ऊपर भरोसा ही नहीं है, विश्वास ही नहीं है, they don't want to see each other's face, they are hating each other, they are having quarrels means लड़ाई झगड़ा. So अगर ऐसा लड़ाई झगड़ा हो रहा है उनके बीच में, they are not into good terms, then the partnership can also be winded up. All right. Next is the point of transfer of interest, where a partner other than the partner suing has transferred whole of his interest in the firm to a third party or has sold his share to the court in the recovery of land revenue arrears due by the partner. So the partnership firm had to pay the land revenue arrears, means government का कुछ पैसा देना था, and they said that since we are not able to repay that, I will sell off my share to other partners. In such a case also the court can dissolve the firm at the instance of any other partner. बार बार आपको लिख रहा है कि कोई पार्टनर उसे बताएगा तब वो डिसॉल्व कर सकते हैं, अदरवाइज नहीं. All right. Continuous or perpetual losses. Now, once I was going through the suggested answers, I saw 3 marks question has come up. There was ABC Associates firm. It was having continuous losses in the business from last 3 years. It is suffering losses. Is it advisable for the firm to continue or not? Now, this is a question having an answer in itself. अब आंसर क्या बन रहा है? 2 लाइनों का है. Where the business cannot be carried on except at a loss in future also, court may order the dissolution. लॉ कहते हैं कि अगर आपके रेगुलर लॉसेस है और एक्सपेक्ट कर ही नहीं सकते आपकी फ्यूचर में आपका प्रॉफिट होगा, देन कोर्ट डिसोल्यूशन ऑर्डर कर सकता है. बट आप पेपर में कैसे लिखोगे? This particular topic relates with the modes of dissolution. One of the modes of dissolution, if you remember section 44, it's okay. Otherwise, you can simply write down. One of the modes tells us about the dissolution, when the court can order the dissolution. Those are the cases where the court where there are the few cases in which the court will order the dissolution. One of them is continuous and perpetual losses. Facts of the case दोगे, conclusion, since the above firm is having continuous losses and the business cannot expect to work other than the loss in future, then the court will order the dissolution. कहने का मतलब एक वर्ड एक लाइन का आंसर है yes or no, but लिखना is something that matters. Okay? Just and equitable grounds. Then there are 4 grounds which have been given, which will be considered as just and equitable. Means कोर्ट इनको डिसाइड कर रहा है कि हमें ये ठीक लग रहा है कि अगर ऐसा कुछ भी होता है तो आपकी फर्म को डिसॉल्व हो जाना चाहिए. Number 1 point is deadlock in the management. A says, I want to run the business in such a way. B says, no, I don't want. I want to manage the business in this way. A says, let's come at 10 a.m. B says, no, we should come at 9:30. C says, no, we should start the office at 11 a.m. मतलब मैनेजमेंट में डेडलॉक है, कोई किसी बात पे सहमत ही नहीं है, लड़ाई झगड़ा हो रहा है, कॉन्टिन्यूस क्वारल्स हो रहे हैं, पार्टनर्स आर नॉट इन टॉकिंग टर्म्स, बात ही नहीं करते एक दूसरे से. क्या आप बिजनेस कर सकते हो उसके साथ जिससे आप बात नहीं करते हो? यहाँ पे तो आप म्यूचुअल एजेंसी है ना आपका, एक दूसरे के लिए लायबल हो तो कैसे बात बनेगी बिना बात करे? लॉस ऑफ सबस्टैंट्रम. सबस्टैंट्रम मीन्स लॉस ऑफ ट्रस्ट एंड फेथ, एक दूसरे का भरोसा ही नहीं, आप तब भी आपका प्रॉब्लम हो सकता. And gambling by a partner on stock exchange. If one of the partner is doing gambling on the stock exchange. So section 40 to 43, dissolution without the order of court, compulsory dissolution, agreement wala dissolution, by notice in case of partnership at will. Right? So those are the 4 cases. In case of contingencies, 4 cases. So no need of court's order. But by court's order, insanity, misconduct, permanent incapacity, persistent breach of agreement, transfer of interest, continuous losses, and just and equitable grounds में हमने क्या पढ़ा? डेडलॉक है, विश्वास नहीं है, ट्रस्ट एंड फेथ नहीं है, लॉस ऑफ सबस्टैंट्रम है, गैम्बलिंग है. इन ऑल दीज केसेस द फर्म विल गेट डिसॉल्व. Alright? Yes, Nikhil, you wanted to ask something. Now you can ask. श्री कृष्णा ने लिखा है अगर 10 पार्टनर्स है और उनमें से एक ने मिसकंडक्ट करा तो क्या फर्म डिसॉल्व होगा या एक्सपल्शन? सो श्री कृष्णा, एक्सपल्शन के लिए आपने टेस्ट ऑफ एक्सपल्शन लगाना है. पहले तो मेजोरिटी ऑफ पार्टनर्स अगर एग्री करेंगे, अगर पार्टनरशिप डीड में लिखा हुआ है एंड इन द इंटरेस्ट ऑफ पार्टनरशिप है, तब आप एक्सपल्शन के बारे में सोच सकते हैं. आउट ऑफ 10 पार्टनर्स, so at least 7 to 8 partners, majority of the partners will agree. Otherwise, if it is a continuous misconduct, other partners can file a case and ask for the dissolution of the. Clear? Yes, Arjun.
यस मैम, थोड़ा एम्बेजलमेंट का मतलब समझे दो ना.
एम्बेजलमेंट मतलब आप कैश के साथ हेर फेर कर रहे हो, है ना, गड़बड़ कर रहे हो. आपने फर्म से पैसा, एक्चुअली में आपके पास 10,000 आया, आप कैशियर हो फर्म के, आपने सिर्फ 5,000 रखा, 5,000 इधर उधर कर दिया, अपने पर्सनल खर्चे कर दिए. ऑलराइट, यू आर मिसयूजिंग.
अच्छा, और लॉस ऑफ सब्सटेंस?
लॉस ऑफ सब्सटेंट्रम का मतलब होता है ट्रस्ट एंड फेथ को तोड़ना, अगेन किसी के भरोसे को. अब मैं आपकी पार्टनर हूँ, 2 पार्टनर्स और है बी एंड सी. मैं बी एंड सी को नहीं बताती हूँ कि मुझे और भी कस्टमर्स मिल गए, क्लाइंट्स मिल गए, और उनको बोलती हूँ ठीक है मैं ही आपका काम कर दूंगी, आप मुझे पैसे दो. काइंड ऑफ पर्सनल प्रॉफिट, सेक्शन 16 में जो पढ़ा था हमने.
हाँ
तो आप
हाँ,
भरोसा तोड़.
ओके मैम, थैंक यू मैम.
अब एक बार जब होता है तो हम बोल देते हैं कि पार्टनर विल बी लायबल टू पे द. बट अगर बार बार कोई करता है तो सेक्शन 44 आपको अलाउ कर रहा है बाकी पार्टनर्स को कि आप केस फाइल कर कर अपने प्रूफ्स लाओ, पॉइंट्स दो एंड फर्म को डिसॉल्व करो.
अच्छा, ओके.
ऑलराइट बेटा. Anybody else? Nikhil, you were raising your hand. Now you can ask your query. प्रभात रॉय, ये क्या क्वेश्चन हुआ कि कौन कोर्ट में बताएगा इलीगल? सो ऑब्वियसली अदर पार्टनर्स विल ना. यस अनिका.
Good evening, ma'am.
गुड इवनिंग.
Ma'am, actually, I had a doubt in dissolution by notice.
ओके.
मैम उसमें मुझे ये डाउट था कि मान लीजिए पार्टनर ए ने नोटिस दिया फॉर द डिसोल्यूशन ऑफ द फर्म, but the other two partners they don't agree with the dissolution, they don't want to dissolve the firm, तो उसमें क्या होता है फिर?
Other two partners don't agree. So what was the reason for dissolution that you have taken up?
Ma'am, I didn't take up the reason actually.
So for what reason you want to dissolve the firm? That is very important to understand the complete question.
Ma'am, maybe because he is not satisfied with the firm. Like there is no forcible reason.
So there is no reason. You have to go through any 7 to 8 reasons given in a section 42. आपको बताना पड़ेगा कि कोई पार्टनर इनसेन हुआ है, परमानेंट इनकैपेसिटी है, कोई मिसकंडक्ट हुआ है, लॉसेस है, क्या रीजन है. ऐसे तो कोर्ट विल नॉट डिसॉल्व द फर्म विदाउट एनी रीजन. So
Okay,
you
ma'am.
have to give a justified reason.
Okay, ma'am.
Okay.
Thank you.
Anybody else? Yes, Nikhil Khanna, you were asking, you were raising your hand. Now you can speak and ask. Meanwhile, I'm checking the queries at the.
गुड आफ्टरनून मैम.
Yes, good afternoon, Nikhil.
मैम आपने जैसे भी बताया था इस पार्टनरशिप
Loud,
में
loud, I can't hear you.
मैम आपने जैसे ही बोला था पार्टनरशिप हमें रजिस्टर कराना कंपलसरी नहीं होता है, मतलब मैंडेटरी है, हमें कराने कराए, नहीं करानी नहीं कराए. तो मैम जैसे अगर पार्टनरशिप जब भी डिसॉल्व होती है, मान लीजिए एग्रीमेंट में लिखा हुआ है कि इतने साल बाद ये पार्टनरशिप डिसॉल्व होगी, तो मैम वो भी कोर्ट में जाकर होगी मैम, क्योंकि हमने रजिस्टर तो कराया नहीं मैम. वो इन द आई ऑफ कोर्ट तो है ही नहीं, लॉ में तो है ही नहीं ना वो पार्टनरशिप उनके लिए. तो मैम वो भी हम कोर्ट में जाके डिसॉल्व होगी.
हाँ
मैम
जी
ये
बेटा,
तो
डिसोल्यूशन का रजिस्ट्रेशन के साथ कोई कंसर्न नहीं है. वो कह रहा है कि कोर्ट में आप तब जा सकते हो अगर आप इनमें से कोई भी केस होता है. सपोज निखिल, आपकी पार्टनरशिप फॉर्म में एक बंदा हमेशा ही मिसकंडक्ट कर रहा है, ऑल्दो आप उसे निकाल भी सकते हो. जैसे श्री कृष्णा ने अपना डाउट रेज करा कि मैम हम उसको एक्सपेल कर देते हैं, देन इट हैज टू बी सॉलिड रीजन. एक्सपेल्शन इतना आसान नहीं होता किसी को करना. एक बार किसी से गलती हुई तो वो सॉरी बोलकर कर सकता है ना कंटिन्यू. बट आप और दूसरा पार्टनर, थर्ड पार्टनर को बिल्कुल लाइक नहीं कर रहे हो, बात भी नहीं करते, तो फिर आपको कोर्ट में जाकर अपना रीजन जस्टिफाई करना पड़ेगा. इसमें अगर आप अनरजिस्टर्ड भी हो तब भी इससे कोई फर्क नहीं.
मैम वो उस तरह से नहीं मैम, मतलब जैसा आपने बताया था कि पार्टनरशिप लिखी होती है कि किसी किसी में लिखा होता है कि फिक्स पीरियड के लिए पार्टनरशिप है हमारी, कि मतलब आज हुई है तो इतने साल बाद इस दिन हमारी पार्टनरशिप वापस डिसॉल्व हो जाएगी, मतलब खत्म हो जाएगी आगे. कोई
बिल्कुल.
कोई केस उस वजह से नहीं हो रही है. तो मैम नॉर्मली जो पार्टनरशिप ऐसे डिसॉल्व हो रही है वो भी कोर्ट में जाके
तो
होगी
पता है
हमारी.
क्या होता है निखिल, एक्चुअली में ऐसे डिसॉल्व होती नहीं है ना. जैसे अब मैं और आप पार्टनरशिप में हैं और हम 10 years पार्टनरशिप हमने करी. अब हमारा बॉन्ड इतना अच्छा रहा कि हम अच्छे से बिजनेस कर रहे हैं, तो हमने ना ही दोबारा फिक्स टर्म करी और साइलेंट रहते हैं और कंटिन्यू कर लेते हैं. तो अब वो पार्टनरशिप क्या बन जाती है, मैंने आपको क्या बताया था, फिक्स पार्टनरशिप.
फिक्स पार्टनरशिप.
खत्म होने के बाद अगर हम फिर भी कंटिन्यू करें तो वो क्या बन जाती है, बाकी बच्चे चैट बॉक्स में लिखेंगे. वो पार्टनरशिप अब क्या बन जाएगी, इट बिकम्स पार्टनरशिप एट विल. वेरी गुड. सो अब पार्टनरशिप एट विल हो गई हमारी, तो अब हम कंटिन्यू कर सकते हैं. अब अगर मुझे खत्म करनी है तो मुझे नोटिस देना पड़ेगा. वेरी गुड
ओके
एवरीवन, दोज हु हैव रिटन द करेक्ट आंसर. गुड. ठीक है निखिल. तो ऐसा नहीं
ओके
है कि मतलब हमें वी हैव टू फाइंड अ रीजन. आप अनरजिस्टर्ड हो तब भी आप डिसॉल्व, तो फॉर्म तो बंद होएगी ना. बिजनेस तो हम कभी भी बंद कर सकते हैं. बट कई फॉर्म्स है जो कॉन्टिन्यूसली बिजनेस करती रहती है, हम फिर दोबारा 10 साल का कॉन्ट्रैक्ट साइन कर लेते
ओके थैंक यू.
हैं. ओके. यस कुणाल.
Good afternoon, ma'am.
गुड आफ्टरनून.
Ma'am, I have a doubt in transfer of interest and just and equitable grounds.
ओके, आई एक्सप्लेन. सो ट्रांसफर ऑफ इंटरेस्ट थोड़ा टफ लगता है बच्चों को, पर उसका मीनिंग बहुत सिंपल है कि मेरी फर्म ने कुछ गवर्नमेंट का पैसा देना था, तो मैंने कहा लैंड एरियर्स रेवेन्यूज देने के बजाय मैंने सारा का सारा पार्टनरशिप शेयर अपना बेच दिया. देखो सेक्शन 29 में वो कहता है यू कैन ट्रांसफर योर शेयर ऑफ प्रॉफिट टू समबडी एल्स. उससे कंफ्यूज नहीं हो. बट आप सारा का सारा ही अपना शेयर दे दो किसी और को, या कोर्ट को बेच दो, या लैंड रेवेन्यू एरियर्स पे ऑफ करने में लगा दो, तो ये एक्सेप्टेबल नहीं अंडर सेक्शन 4. दूसरा वो कहते हैं जस्ट एंड इक्विटेबल ग्राउंड्स में आपको 4 उसने चॉइसेबल रीजन दे दिए. जस्ट एंड इक्विटेबल का मतलब क्या होता है, कानून की नजरों में जो सही है, जो कानून को ठीक लग रहा है, व्हाट इज फेयर इन आईज ऑफ द लॉ. इक्विटेबल मतलब मुझे पता है कि ये करने से सबका फायदा होगा, इक्विटेबल इंटरेस्ट. उसका केस है डेडलॉक इन मैनेजमेंट, मीन्स मैनेजमेंट में बहुत गड़बड़ है, कुणाल कुछ कह रहा है, उसका पार्टनर निखिल कुछ कह रहा है, भानु कुछ कह रहा है, तो दैट मीन्स मैनेजमेंट हो ही नहीं सकती। अगर सब लोग अपनी अपनी राय देंगे तो नहीं हो सकती, राइट। फिर लॉस एंड सबस्टेंट्रम मैंने अभी समझाया, भरोसा तोड़ रहे हो आप किसी पार्टनर का, गलत कर रहे हो। फिर आप कौन सा था बाकी पॉइंट, डेडलॉक इन मैनेजमेंट है, लॉस एंड सबस्टेंट्रम है, यस कुणाल, कॉन्टिन्यूस लॉसेस है, गैम्बलिंग कर रहे हो, पार्टनर्स
Yes,
एक
ma'am.
दूसरे से बात नहीं कर रहे, तो फिर आप बिजनेस नहीं कर सकते। ठीक है बेटा,
Okay, ma'am.
ऑल ओके। तो सबके डाउट्स क्लियर है रजिस्ट्रेशन डिसोल्यूशन को लेके, कैन वी मूव अहेड? So this was an important question. Section 44 is very important and we have just completed that also. Rachna, I hope your doubt was clear now. Sandeep Thakur, Kunal. Very good, Padla Patri, all those who have given the correct answers. And students on the portal, I can see your queries. I can only see Mr. Vikram Sharma. Okay, partnership was formed for 20 years. Yes, Sarla Devi want to ask something. Yes, Sarla.
Ma'am, just I wanted to ask, say there is a three partners, A, B, C. Because of one person's problem, the whole company is going to dissolute. Is it correct?
So
Because two partners are correct, no? So why it
yeah.
is? Because building a business, making a business in one stage, they have long time they have built the business because of one reason, because of one partner's reason, the whole company is going to dissolve. So
So, Sarla, I will explain you this point. It's a very, very simple question and very simple answer to this. Suppose Harleen, Sarla, and Banu, we three are partners. So, Harleen is doing misconduct and she's not doing the business regularly. So, Sarla and Banu decide that, okay, fine, we will dissolve this firm because I am being named in that firm, right? But who is stopping Sarla and Banu to go and continue the business? You dissolve this firm by order of court, take the order of the court, dissolve our name, cut my name from the firm, and you can feel free to continue.
Okay, thank you.
All right?
Yes, ma'am.
मैम 5 मार्क्स में क्वेश्चन आया जिसमें सारे सेक्शन बताने हो तो फिर सर यस तनीषा, देन यू हैव टू राइट ऑल दीज पॉइंट्स, ओके। एंड आई होप तनीषा ट्रांसफर वाला पॉइंट अब आपको समझ आ गया है। Okay. Let's continue further. So let's take up a case study. A partnership was formed for 20 years, was continuously suffering losses. One partner withdrew after some time, but the two other continued. Subsequently, one partner filed a suit for dissolution. It was held continuous loss can be a ground of dissolution. तो इस केस में आप बोल सकते हो, आपके पास स्पेसिफिक रीजन है, वही वाली बातें जो आप अभी कह रहे थे कि मैम 20 इयर्स है, गुडविल है, फेथ है, विश्वास है, बट लॉसेस हो रहे हैं ना, तो फिर क्या फायदा है, पार्टनर विड्रॉ कर रहा है, सिर्फ 2 ही रह गया, तो फिर सब्सिक्वेंटली एक पार्टनर फिर केस फाइल। रिफ्यूजल टू मीट ऑन मैटर्स ऑफ बिजनेस, continued quarrels with no hope of mutual cooperation. वॉटने वर्सेस वेल्स का एक केस हुआ था जिसमें उन्होंने कहा था बार बार लड़ाई झगड़ा हो रहा है। अब आप मुझे खुद बताओ कि आप जब स्कूल में थे या कॉलेज में थे, अगर आपको कोई बच्चा नहीं अच्छा लगता था तो आप आपस में बात नहीं करते थे। तो क्या अब आप अगर आप आपस में बात नहीं कर रहे हो, सपोज आप किसी को लाइक नहीं करते हो, हर किसी के फ्रेंड्स भी होते हैं, फो भी होते हैं, एनिमीज भी होते हैं, राइट? सो इफ यू आर नॉट टॉकिंग टू ईच अदर, सिटिंग विद अ फेस ऑन द अदर साइड, can you people do business together? Can I do a business with somebody whom I don't like to see, whom I don't like to talk to? No, ma'am, simple. Everybody says correct. So that's the reason, absolutely. So if there are continuous quarrels and you're not liking, you're not happy, get it dissolved. There's no problem. But whether the dissolution of the firm or only reconstitution is required, this is just an important point I wanted to share with you. Partnership was for 6 years, and after that time, same was stated to have dissolved by mutual consent, and the business with its assets and goodwill belonged and carried by the continuing partners. Like I just explained you, we have dissolved it, but other partners want to continue, you can. But please remember, dissolution and constitution are two different legal terms. In dissolution, the entire partnership will come to an end for once. But the reconstitution is the continuation under the altered circumstances. So in the present case study, the firm was dissolved after 6 years, also by mutual consent. The old firm stood dissolved, and now it is being run over by the continuing partners. Therefore, the new firm has succeeded. Are you understanding? Let's take an example. ABC Associates was there. Mr. A was doing misconducts or any problem for 6 years, and then B and C filed the case, and the ABC Associates get dissolved. Now, B and C want to still continue, so they have formed BC Associates. And this is a new firm which has succeeded the business of the old firm. So here, dissolution has happened. When a partner has joined, their reconstitution is happening. So that is the difference. Reconstitution can happen after dissolution also. Now let's do the consequences of dissolution. I'll complete the chapter first, and then I'll give you a break, and then we'll do the further case studies. Consequences of dissolution. Liability for the acts of the partners done after dissolution. So law says whatever liability occurs for any acts done after dissolution. So until public notice is not given, the partners and the firm continue to be liable to the third party. Point number 1, आपने firm dissolve कर दी 1 October 2024. अब जब firm dissolve हुई है तो आपको public notice तो देना चाहिए ना, आपको बताना तो चाहिए जो outsiders हमारे साथ डील करे कि आप हमारा बिजनेस नहीं चल रहा है, आप हमारा काम बंद हो गया है. So जब तक आप वो नहीं बताते हो, आप liable रहोगे towards the third parties. However, the state of deceased partner not known to the third party, that means the dormant partner, insolvent partner will not be liable for the subsequent acts even after the notice of dissolution is given, even if no notice has been given. So it says point number 1, all the partners, so that means all the active partners are liable even after the date of dissolution if public notice is not given, but death of a partner, dormant partner, insolvent will not be liable. Like you did in retirement of a partner, उसमें भी ये तीनों लाइबल नहीं थे, डिसोल्यूशन में भी ये 3 लोग इंसॉल्वेंट, डेथ एंड डोमेंट पार्टनर लाइबल नहीं रहते. एंड पब्लिक नोटिस कैन बी गिवन बाय एनी पार्टनर, कोई भी पार्टनर जाके पब्लिक नोटिस दे सकता है. बेसिकली आपको थर्ड पार्टी को, बैंक्स को बताना है कि अब हमारी फर्म बंद हो गई है, हम बिजनेस नहीं करते. So section 45 typically talks about the liabilities for the acts of the partners done after dissolution. After dissolution आप कुछ भी एक्टिविटी कर रहे हो तो आप थर्ड पार्टी को 100% लाइबल. Liability to have the business wound up after dissolution. अब वो बिल्कुल क्लियर है कि आप अपने डेट्स क्लियर करो एंड सारा शेयर जो है पार्टनर्स पे बांटकर, इट इज योर राइट टू वाइंड अप द बिजनेस. एबीसी एसोसिएट्स 3 पार्टनर्स थे, उन्होंने डिसॉल्व कर दी फिर, तो अब उनकी रिस्पॉन्सिबिलिटी है कि सारे एसेट्स वगैरह बेचकर, लाइबिलिटीज क्लियर ऑफ कर बिजनेस को वाइंड अप कर दे, खत्म कर. Continuing authority of partners for the purpose of winding up, section 47. It says a mere dissolution will not bring a complete extension of the firm which continues until the liability are not paid. No partner can claim any particular property or his share case. Section 47 क्या समझा रहा है आप? वो कह रहे continuing authority of the partners for the winding up. 1 February 24 को डिक्लेयर हुआ कि फॉर्म डिसॉल्व, सारा फैसला हो गया, या कोर्ट ऑर्डर था या नोटिस था, जो भी था, इस दिन फैसला हो गया. अब बेटा इतना टाइम का आपने बिजनेस करा है, एसेट्स हैं, प्रॉफिट्स हैं, डीलर्स हैं, एकदम तो नहीं ना सब कुछ बंद होता. सो ये सब फाइनल क्लोजर बुक्स के करते करते, अकाउंट्स क्लोज करते करते आपको 5 जून 24 हो. अब वो कहते हैं 5 जून 24 तक जो भी आपके खर्चे थे, लाइबिलिटीज थी, उसके लिए फर्म लाइबल रहेगी. पहले आप बाहर वालों को पे करोगे, आउटसाइडर्स को, थर्ड पार्टी को, फिर कोई अपना शेयर ऑफ प्रॉफिट्स एंड एसेट्स. सो इट सेज नो पार्टनर कैन क्लेम एनीथिंग, मींस आप कुछ क्लेम नहीं कर सकते जब तक आप अपने बाहर आउटसाइडर्स की लाइबिलिटी को पूरी तरह से पे नहीं कर देते. Is that clear? All right. Section 48, mode of settlement of account between parties. Now, this is very, very simple. In fact, you have been doing accounts questions, so you know better than me how this section 48 have to be resolved. So, mode of settlement of account between partners says if the firm has had losses, then first the payment will be made by profits, then capital will be used, and then the personal assets have to be used. Right? Suppose there are deficiencies of capitals and the losses the firm has been happening, then first the profits will be used, capital, and then the personal assets. And how the assets of the firm has to be used for making payment? First, the third party outsiders will get the payment. Then the capital contributions, apart from the capital contribution, whatever the advance has been given by the partner, that will be paid off. Then the capital contribution of the partners, and the balance will be divided among the partners in profit sharing ratio. Is that clear to everyone? So how the mode of settlement happens? Section 48A tells you the losses have to be applied first for the profits, capital, and then the personal assets. And the assets have to be paid first to the outsiders. You sell off the assets and you pay the outsiders. Then you pay the partners their share from the advances. Then the capital is given and then the profit sharing ratio. I hope no doubts still here. Yes, Ravi Kumar. Okay. Riddhi, I hope your doubt for transfer was now clear. Somebody has written something, I can't find. Okay. So this is very, very simple. And the last point is payment of the firm debts and the separate debts. Now, what is the meaning of firm debts and the separate debts? It says property of the firm will be used in making the payment of the firm debts first. And if there is any surplus, then we will pay the separate debts of the partners. Say, for example, a partner has also given a loan to the firm for 10,000. Listen very carefully. A partner has given a loan of 10,000. When we wind up the business, we sold the assets. The assets were sold for rupees 50,000. And the debts of the firm were rupees 40,000. So out of this 50,000, हम पहले किसको pay करेंगे? Outsiders को 40,000. And फिर जो बचा है 10,000 वो partner का debt हम pay करें. बट अब हम जब पार्टनर की पर्टिकुलर प्रॉपर्टी है, सपोज जो टेबल था वो एक पार्टनर लेकर आया था, उसकी सेपरेट प्रॉपर्टी को हम सेल ऑफ कर पेमेंट्स करें या फिर उसके पर्सनल एसेट्स सेट ऑफ करें, तो फिर जब हम उसके पर्सनल एसेट्स को सेल करेंगे, सेपरेट प्रॉपर्टी ऑफ अ पार्टनर विल बी यूज्ड फॉर, देन वी विल फर्स्ट पे 10,000 ऑफ दैट पार्टनर, एंड इफ एनी बैलेंस इज लेफ्ट, से फॉर एग्जांपल 30,000 वाज लेफ्ट, then 30,000 will be given to the remaining 40,000 debt holders. So separate debts की separate payment है. फर्म की डेट्स की पेमेंट के लिए आप पहले फर्म का यूज करोगे. ठीक है? Clear? So now we have case studies, but I'll just show you. Okay, Vindhya is asking, ma'am, in public notice published in newspaper. Yes, Vindhya, it depends. You can give it in the newspaper or you can announce it. You can tell the advertisements can be given. You can tell your outsiders, whosoever is dealing with the business, that public notice has to be given that you're no longer running the business. You have dissolved. Okay. Yes, Tanisha, are you asking any question? Yes, Tanisha, all these sections we will be doing from the study material also, because while I'll be giving you a break, I will request all of you to read all these sections from there also. So section 45 is very simple. Liability of the partners after dissolution means till the date of public notice. तो यहाँ पे याद रखने वाली क्या बात है? Public notice तक आप liable रहते हो, but death of partner, unknown partner, that is sleeping partner, they are not liable. So these are the 2 points which you have to remember. Let's do example number 5. X and Y, who carried on the business for several years, executed on December 1 a partnership deed dissolving the partnership from the date, but they failed to give the public notice. On December 20th, X borrowed in the firm's name a sum of money from R, who was not aware of the dissolution. In such a case, Y will also be held liable because no public notice was given. Can anyone explain me example number 5 and tell me why Y is held liable? X ने borrow करा है R से पैसा, firm dissolve हो चुकी है. Why Y is held liable? Can anyone tell me this point? Anyone would like to raise their hands? Yes, Manushri. Manushri, I can't hear you. Yes, Rachna.
गुड आफ्टरनून मैम।
Good afternoon.
मैम इसमें बताया है कि जो एक्स और वाई ने थी वो 1 दिसंबर को पार्टनरशिप डिसॉल्व कर दी, बट कोई पब्लिक नोटिस नहीं दिया। तो इस केस में क्या होगा कि अगर एक्स ने कुछ बोरो किया आर से तो वाई लाइबल होगा, बिकॉज दोनों म्यूचुअल एग्रीमेंट अभी भी मतलब आर के पॉइंट ऑफ व्यू से तो दोनों अभी भी पार्टनर्स हैं, तो फिर वो
Very
वाई
good.
भी
So,
लाइबल
principle of mutual agency. Good, Rachna. Principle of mutual agency exists between the partners because they still continue to be the partners. Okay. Yes, Nikhil, you want to say something?
Ma'am, because in this case, why would not be given a public notice?
Okay,
Ma'am, why
voice is not coming. Yes, Fadla Bharti.
Ma'am, here there is no public notice has given and there are no dormant partners in this case. Both are active partners. So public notice is essential for this.
Excellent. The next question that I was going to ask you is, if Y has been a sleeping partner, then will Y be held liable?
No, ma'am.
Very good. Very good. And if Y was insolvent partner?
No, ma'am. In case of insolvent or dormant, he is not liable.
Okay, very good, Padla Bharti. And another question for the class, if the ex-partner who has borrowed the money and Y partner has died, will the legal representative of Mr. Y held liable for this, even if public notice was not given? If Y has died, will the legal representative, estate of the deceased partner, will be held liable? Yes or no? So the answer is no. Perfectly fine. All of you have answered it correctly, because in these three cases, they will not be held liable. All right. So we will continue from section 46 to 48 from the module, and then we will do the case studies. So let's take a small break here, and I give you time to go through whatever we have done, and then we'll complete the chapter. Okay. All right. Okay, so we are taking a break here. Anji students, let's continue. Anyone having any doubts still here, you can raise your hands and ask. No doubts, shall we proceed ahead? Yes, Rachna.
मैम मुझे सेक्शन 46 और 47 समझना था.
Sorry, please come again, Rachna.
Section 46 and 47.
All right, we will be doing those from study material also. What is your specific doubt in section 46?
मैम सेक्शन 46 में बोल रहा है कि राइट ऑफ पार्टनर्स टू हैव बिजनेस वाउंड अप आफ्टर डिसोल्यूशन. मतलब इसमें वो क्या मतलब जैसे कि बिजनेस वापस कंडक्ट कर सकते हैं जो अदर पार्टनर्स होते हैं.
All right,
या
I'll
फिर
explain. So, right of a partner to have business wound up means it is your right as well as responsibility. Like अब किसी partner को लग रहा है कि मुझे business wind up करने के लिए ये सब rights अपने use करने. So he tells you that for the purpose of dissolution, you have to use the property of the firm for paying the debts and liabilities. And if there is any surplus, then you will distribute among the partners, and also the legal representatives will get according to their rights. Means ये आपका right है. Means you have your responsibility and rights that you have to wind up the complete business. And then section 47 tells you the continuing authority, whatever is your responsibility and authority till the date of winding up, you have to continue and complete. The most important section is section 48, which we just did. So your profits, the losses that you're having will be paid out of the profits first and then out of the capital. And if necessary, individually, the partners, the sharing of profit have to be announced. And the assets will be used in paying off the debts of the firm, paying the partners for the any advances. Please write down here any advance money from the partners, then paying off the capitals, and then any residue in the PSR ratio. I hope, Rachna, your point is clear. Let's move to
yes,
example.
ma'am.
All right.
मैम सेक्शन 47 में और ये जो सेकंड पैराग्राफ है वो वाला एक बार बता दीजिए ना.
ये वाला बेटा, the firm in no case is bound by the acts.
Yes, ma'am.
Again, वही वाली बात है, insolvent partner अगर कुछ कर रहा है तो firm is not bound. We have already discussed this point in case of insolvency, that any acts done after the date of insolvent, the partners are not liable. Dissolution के लिए वो कह रहे हैं हर पार्टनर एक दूसरे को बाइंड करेगा. म्यूचुअल एजेंसी, म्यूचुअल राइट्स एंड ऑब्लिगेशंस है वो कंटिन्यू रहेंगी जब तक फर्म डिसॉल्व नहीं हो जाती. कंप्लीट ट्रांजेक्शन बिगन बट अनफिनिश्ड, कहते हैं जब तक खत्म ना हो रहा है वो बाइंडिंग अप तब तक आप सारे जिम्मेवार. बट इन केस द एक्ट ऑफ द पार्टनर हैज बीन adjudged insolvent, this provision will not affect the liability of the person who has represented himself or knowingly represented to himself as a partner of insolvency. So वही वाली बात है, insolvent partners acts will not be affected. Clear?
Okay. Yes, ma'am.
Now let's do example number 6, which is very, very important. Another case study which is given in the module itself. X and Y are partners sharing the profit and losses equally, and X has died. On taking partnership accounts, it transpired that he contributed 6,60,000 to the capital of the firm, and Y has contributed only 40,000. However, the total assets which were left were rupees 2 lakh. Now, how the deficiencies will be paid out? So, out of 6,60,000 plus 40,000 is your total 7 lakh rupees, the capitals that they have contributed, minus the assets. So 5 lakh liabilities is to be contributed equally by X and Y's estate. Can anyone tell me that why needs to contribute equally? He has just given 40,000 rupees of the capital, and X has given so much capital, and now he is giving 2,50,000 more. Yes, Rachna.
तो मैम इसमें ऐसा बताया है बिकॉज वाई और एक्स दोनों पार्टनर्स है और दोनों मतलब इक्वली लाइबल होता है अपनी लाइबिलिटीज के लिए, तो फिर अगर वाई ने कम भी कैपिटल शेयर किया तो वो लाइबल होगा।
Very good, because this word is very important, that the profit sharing ratio is equal. Absolutely correct, beta. Good, well done. So you cannot say that I will differentiate because I have contributed less capital or no capital. If it is equal profit sharing ratio, equally they will be held at. Agreement provided on dissolution, the surplus assets will be divided between the partners according to their interest on the capital, and on dissolution, any deficiencies found, the assets will be divided in proportion to their capital. With the result, X estate would be the main loser. वो तो हमें पता ही लग रहा है क्योंकि उसने ज्यादा कैपिटल दी थी, तो अब उसको प्रॉफिट भी ज्यादा ही, कैपिटल कंट्रीब्यूट तो ज्यादा ही करना पड़ रहा है. So if you're having that might be a loss for you in the later. Now, payment of firms and separate debts. I hope this doubt point is also clear. I want to ask you one question out of this. If there are joint debts due from the firm and also separate debts due from the partners. There were three partners, Mr. PQR, and it is a PQR Associates firm. The firm owed to the outsiders rupees 15,000. And there is a partner, Mr. P, who has lent money to the firm for rupees 16,000. Now, when the assets of the firm were sold, they were for rupees 40,000. How will you pay the debts which are jointly due from the firm and separate debts from the partner? You can raise your hands and answer me. All right, who is going to answer me? Let me see the answers in the chat box. First preference will be given to separate debts. Are you sure, Sarla Devi? Yes, Tanisha, what is your answer? Yes, Sarla.
Because he is also be considered as an outsiders only, ma'am, in this capacity, not as a partner, as an outsider.
Read the question carefully. I have said assets of the firm are for 40,000. If we apply the first principle, property of the firm will be applied for what?
Outsiders.
Yes.
Outsiders.
Yes. Absolutely correct. So out of 40,000, first we will pay 15,000, the outsiders. We still have a surplus of 25,000 left. Please give rupees 16,000 back to Mr. P. Fair enough? Wonderful. Now, if the assets of the firm has already been used, and now we are selling the personal assets of the partners. And when we sold personal assets of Mr. P, it turned out to be 20,000 rupees. Now, who is going to tell me how the debts will be paid off? Now, the separate property of the partner has been sold. So, separate property of the partner has been sold for 20,000. It will be first used for paying the 16,000 rupees, the debt of Mr. P, and balance 4,000 will be given to the debts to whom we owe 15,000. Is that clear to everyone? That is how section 49 has to be applied. Now let's start the case studies. Subject to the agreement by the partners, state the rules that should be observed by the partners in settling the accounts of the firm after dissolution under the provisions of Indian Partnership Act 1932. Now this is a 4 marks examination question which is asking you clear-cut about the settlement of the accounts. Quickly write your answers in the chat box. What will be the correct answer? Everyone has given the correct answer. Well done. I'm still waiting for others to answer this one. Yes. Vindhya, the previous answer was correct. Bhanu, previous answers were correct. Give the answer for this one. Yes, Sarla Devi, this one is also correct, but you have to give the correct full answer applying section 48. So we have just done the mode of, now this is a clear-cut question, children. ये सारा exactly question में दिया हो. अभी जो हमने पढ़ा section 48 mode of settlement, 4 marks का उसने यही पूछा. तो as it is आप legal language में लिखेंगे. This is a direct question. Mode of settlement, section 48 in settling the accounts after dissolution. Losses, including the deficiencies, will first be paid out of the profits, lastly by all the partners individually, first out of the profits, then out of the capital, and if necessary, individually from the partners. And the assets will be contributed for paying the debts of the firm, in paying the advances due other than capital, any amount of capital, and residue, if any, will be shared among them in the profit sharing ratio. So settling of the accounts, याद रखना है mode of settlement of accounts, section 48 का direct question. Is that clear? Now discuss the provisions regarding the personal profits earned by a partner under Indian Partnership Act. Now this is also a 4 marks examination question. This will help me to understand. Very good, Vindhya. Absolute correct answer given by you. So this is also 4 marks question. Again, all of you have to answer this one. Yes, Tanisha, good answer. Yes, Sri Krishna, you want to speak and answer this one? You can speak. Absolutely correct, Rachna. You have mentioned the correct section, but I wanted you to write the answer also.
Yes,
Sri.
ma'am.
Yes.
If partner derives a profit from his business, own personal business, then he shall pay for it to the firm.
Yes, but how will you write it? I told you section 16 is one section I wanted to learn the legal language.
Ma'am, if a partner carrying same type of business, then whatever the profit he will made by his own firm, he shall liable to pay off all that profit to the firm.
All right. Well tried, Shri Krishna. Good. Yes, Arjun.
Yes, ma'am. As per section 16 of the Indian Partnership Act, the provision regarding personal profits earned by a partner, provisions that there are 2 provisions basically that if a partner derives any profit for himself from any transaction of the firm, but then from the use of the property or the business connection of the firm, he shall account for the profit only and have to pay the profit to the firm. Otherwise, he will not get the share of the profit. If a partner carries on any business of the same nature as in competing with that of the firm, he shall be also held liable.
Absolutely
for
correct.
to
Well
pay
done, Arjun.
all.
I hope you're not referring to the module.
No, ma'am, I am
Well
telling on my own.
Very good, beta. Well done. So that is what I want, the way you have learned. Everybody should learn in the same way. So section 16 nahi bhi yaad aaya, to as per the provisions of Partnership Act, subject to a contract between the partners, please लिख ही देना, because हर किसी में common है. अगर आपको कॉन्ट्रैक्ट हुआ है, मैं आपकी पार्टनर हूं, मैंने बोला हुआ है कि आप कर लो पर्सनल प्रॉफिट्स, तो कोई बात. सो ये लाइन लिखनी जरूरी है. एम्प्लॉयड अथॉरिटी में भी, सेक्शन 16 में भी, subject to the contract between the partners. If any partner has derived any profit for himself or from the use of properties, name, business connection, firm's name, he must account for that profit. And if partner carries on the business of the same nature competing with that of the firm, he shall account for the firm all profits में. दोनों में ही बातें सेम है, उसे अपने पर्सनल प्रॉफिट्स रिटर्न करने पड़ेंगे, पर दोनों ही केसेस डिफरेंट. चाहे आप कंपीटिंग बिजनेस कर रहे हो, चाहे आप उसी में से प्रॉफिट खाकर अपने पास रख रहे हो. State the modes by which a partner may transfer his interest in the firm in favor of another person. What are the rights of such a transferee? Again, a 4 marks question, children. Now you should do your writing practice. This is a direct assignment being given to you in the class, so that we can understand how much have you actually understood the principles and how you have applied. I give you 2 minutes to think and answer in the chat box, so you can raise your hands also. Akshit Verma is asking, ma'am, law में numerical questions आते हैं बेटा? Numerical question कोई math solve करना तो नहीं आता है, but yes, there can be capital given, there can be partnership figures given for the settlement and dissolution. Keep yourself on mute. Somebody has unmuted. Yes, I'm waiting for your answer, student. Okay, Mr. Gagan would like to speak. Yes, Mr. Gagan. Gagan, your voice is not coming. Tamanna has asked the meaning of loss of substantium. I hope, Tamanna, your doubt is now clear because we explained to you later on that it means loss of trust and confidence between the partners. Permanent incapacity asked by Drashti Jain. Permanent incapacity means a partner कोई बंदा कोई चल फिर नहीं सकता, उसकी body jam हो गई है या legs move नहीं कर रही है. Permanently incapability, कोई physical disability. Yes, Mr. Gagan, can you speak? We can't hear you. Mr. Prince, your answer was correct for the previous one. Kausar Ansari, correct answer. Half of the firm is not a good word, Kausar Ansari. अब आपने लीगल प्रोविजन चेंज कर दी तो ये गलत है. श्री कृष्णा आपने लिखा हुआ है मैम, एक बार फिर बता दो. व्हाट वर यू आस्किंग? यू कैन आस्क अगेन. यस परी, यू विल गेट मोर क्लासेस आल्सो, डोंट वरी. शिवम व्यास, पलक भरद्वाज, सॉरी. शमरीन आपने लिखा है पब्लिक नोटिस नहीं दिया इसलिए लायबल है, बट देन यू हैव टू राइट दैट पॉइंट that he was held liable because of the principle of mutual agency. This Padula Parthi, good answer for the previous one. Yes, Mr. Satish, correct. Sandeep Thakur, section 29 is good, but you should have written section 29. So this is what you have to write over here. Section 29 provides that any share in the partnership can be transferred like any other property of the partner, but as the partnership relationship is of confidence, mutual confidence, the assignees of partners' interest by sale or mortgage cannot enjoy the same rights as of the original partner. His rights will be during continuation. क्या क्या right था? Not to interfere with the conduct of the business, not to inspect the books, only to enjoy the profits that he get. He cannot challenge the accounts. Okay, Sarla. And on dissolution, what all right he get?
Ma'am, in the Indian Partnership Act 1932, a partner cannot transfer his interest in the firm freely like in a company like, because the partnership is based purely on mutual trust and agreement among partners. There's a reason why he cannot.
So after discontinuation, what is his rights?
But this is the reason why,
You cannot transfer your share. This is what you're saying.
Now the question what you asked, no, ma'am, earlier.
This one in which a partner has
transferred, by which a partner may he cannot, transfer. He cannot transfer his interest.
Section 29, he forgot.
Okay.
All
yes,
right. Yes. So that one that you were talking, Sarla, that is a case of dissolution where you're transferring whole of your interest. That is not allowed. Court can order the dissolution, but here specific section 29. That's why I took up this question in chapter of dissolution so that you don't get confused between 2 points. And on dissolution, children, what will happen? He will get all the assets of the firm to which transferring partner was entitled, and also he can now check the accounts. Please remember that no partner can be introduced without the consent of all the partners, and partner cannot transfer unless the other partners have accepted that person as a partner. At the same time, a partner is not debarred from transferring his interest, but it is the existing interest in tangible properties that can be assigned to another person. Maybe his share of profits or his property, he is giving some share to another person. Now, this is the last case study, and after this, we will be moving to examination questions. So I give you 2 minutes, read it very carefully, and I want all you to write the answers in the chat box. Everyone is going to do this question. I'm waiting for all of you to write your answers. I have received 16 answers so far. Very well tried, Vindhya, Rachna. This is for the previous one. Tanisha. Okay, anybody would like to raise their hands and answer? Very good, Tanisha. Ma'am, registered firm के register में transfer का नाम no. Tanisha, his name will not be there. Very good, Sandeep Thakur. Yes, Sri Krishna.
Yes, ma'am. Ma'am, until the public notice is given, all partners are liable to third parties for their acts on behalf of the firm before or after dissolution is made. So, in the instant case, no public notice is given. So, by the mutual agency concept, Y will liable to Z.
Okay, very well tried, Shri Krishna. Just mute yourself. So children, see, many a times I feel you know the answer, but it's all about the representation. So I keep on telling you again and again, as per the provisions of Indian Partnership Act, we will start. No partnership will get dissolved and the partners will continue to be liable. So section 45 जो हमने अभी पढ़ा, partners will continue to be liable to third parties for any acts done until the date of public notice. थोड़ा सा ना मतलब legal language चाहते हैं वो कि वैसे लिखो. फिर इंस्टेंट केस दे दो कि ऐसे ऐसे फॉर्म डिसॉल्व हुई, पब्लिक नोटिस नहीं दिया एंड गुड्स परचेज करे. बताओ तो सही उसे कि हमने गुड्स परचेज करे फ्रॉम जेड हु इज नॉट अवेयर. एक्स इंसॉल्वेंट हो जाता है एंड जेड फाइल्ड केस अगेंस्ट वाई फॉर रिकवरी. Now, X and Y are continuing liable after the dissolution until public notice is given. Remember, I told you 3 cases you're not liable: if you are a sleeping partner, if of death of a partner, in case of insolvency. So here X has become insolvent. Shri Krishna, mutual agency का तो कोई रोल ही नहीं था बेटा यहाँ पे. एग्जामिनर क्या बोल रहा है आपको? वो बता रहा है आपको कि वो इंसॉल्वेंट हो गया है. सेक्शन 45 की एक्सेप्शन में क्लियरली लिखा हुआ है कि अगर आप इंसॉल्वेंट हो जाते हो फिर आप लायबल नहीं हो. Therefore, only Y will be held liable to C. And only few students have written this correct answer. I'm still checking the work, Nishtha. Your answer, very good. Correct answer, Nishtha. Ankit Verma. Very good, Ankit. Akshit Verma, sorry. Akshit Verma, your answer is correct. Some maths can be given to, yes, Arjun, it can definitely happen. Y is not liable. Why are you saying Y is not liable, Arjun? Wrong answer.
Ma'am, because ma'am, even after becoming X become insolvent, then how come Y will be liable to pay Z? It's entirely upon Z who X who purchase goods from
No, beta.
Z on
That is
risk now.
obviously one act of the partner is binding on the other, but read section 45 first. Take 1 minute and read it. I'm just checking the other queries. Then I will discuss. Yes, sir. Love.
The fact of this case is, the firm was dissolved on 12 June 2022. No public notice of dissolutions was given. After that, X purchased goods from Z in the firm's name. Z had no knowledge of the dissolution. According to section 45, since no public notice was given and Z was unaware, the act of X binds the firm. Hence, Y, though he a retired dissolved partner, remains liable to Z along with X. Even though X later become insolvent, Z can claim the amount from Y because the firm's liability continues until public notice is given. I just tried, to write that.
This type of answer you write in the exam, you can read what I've written for you. Excellent.
Thank you.
Well done.
Thank you.
Well done. Well done.
Thanks.
Arjun, I hope your doubt also got cleared, Bacha, because 3 exceptions.
Yes, ma'am. I've missed the last 3 points. Na, that an insolvent partner is not liable to pay off the debts.
Yes. Yes.
ठीक है.
Yes. Mr. Prince, your answer is correct. Kausar Ansari, your answer is correct. Shri Krishna. Yes, your answer is correct. Riddhi. I'm just reading all your answers. Yes. Yes, Sandeep.
Yes, ma'am. I have a little query. Ma'am, मान लीजिए in case यहाँ पे unsound mind person मतलब unsound mind partner होता है, मैम वो भी liable हो जाता है.
बच्चा अगर अनसाउंड माइंड का है कोई तो What did you say, Sandeep?
Yes, ma'am. Yes, ma'am. Unsound mind अगर रहता है इसमें अगर एक partner.
So वो लायबल नहीं होगा बिकॉज उसके लिए अदर पार्टनर्स जहाँ पे फॉर्म के लिए डिसोल्यूशन के लिए बोलेंगे ना, देन ही इज नॉट लायबल. Okay. So well on time, we have completed our syllabus also, students, and I hope I was able to answer all your queries. So let me just take you to that January 2025 question paper also, so that we can just discuss that and then we'll wind up the session. So you can see first question, which is mandatory. It is generally from the Contract Act, and then it is Companies Act, second question. And the third, which is out of the compulsory questions, 6 marks question out of the partnership. So a minor admitted for the benefits of partnership is entitled to certain rights and may have certain liabilities. Discuss the rights and liabilities before attaining majority only of the minor. मतलब 6 नंबर का clear cut question section 30 का आया हुआ है, in which you beautifully have to express your points that till the time you are minor, your right to share the profits, agreed share of profit, he can access the accounts. But if he want to file a case, he has to cut his connection. Then you write the point of attaining majority, 6 months time period. And what are the liabilities? Liabilities are same as extent of the share of profits. He has no personal liability, cannot be declared insolvent. In firm is declared insolvent, he can recover his share. You write these 6 points, 3 to 4 points of rights, 3 points of liabilities, you get good marks. But you have to express yourself. Don't go what happens after majority. He has specifically asked you about before majority. Clear हो गया? एक 6 नंबर का क्वेश्चन हमने सॉल्व कर लिया जनवरी क्वेश्चन 2025. Then let us see question number 3, A part, which Kunal somebody has asked. 7 marks question. PQR are partners in construction firm, PQR Associates. P buys cement on behalf of the firm from D. Cement is used in the ordinary course of the firm's business. P uses the cement for his personal purposes. Supplier is unaware of the private use of cement by P, claims the price from the firm. Firm refuses to pay for the price on the ground that cement was never received by P. Now, whether the firm's contentions are correct or not, what would be your answer if cement was purchased, was delivered to the firm by him, and rest was used by him for private use? Now, here examiner has given you a question related to section 16 and section 18. How you have to apply it is something that we need to understand. So quickly, let's see the answer. So section 18 read with section 25 and 26 has been applied. Any partner is an agent of the firm and they hold the character of principal and agent. So पहली बात तो आप बता देंगे कि partners एक दूसरे के agent है. Knowledge of one partner is knowledge of another. So partners are jointly and severally held liable. Here, act of a partner done, any omission by the partner, all the partners will be liable. And firm is liable for the ordinary course of business and within the authority. Here we are assuming he has acted within his authority, so firm will be held liable. Sex action is applicable only for the acts done for the purpose of business. P, a partner, buys the cement in the ordinary course of business. उसने आपको बता दिया है. He uses it for his personal purposes. D was not aware of the private use and is given. Now, अब उसकी D की तो कोई गलती नहीं है ना. So he has acted, partner has acted as an agent. Since P buys the cement in the ordinary course, therefore firm's contention to refuse is not tenable. Not tenable means ये acceptable नहीं है. Firm को उसके लिए pay करना ही पड़े. Further, for the wrongful act done by one of the partner, अब एक partner अगर कोई गलती कर रहा है ordinary course में within the authority, part of cement was delivered by the firm to him and rest was used for private use. Since here the act of P to purchase was in the ordinary course of business within the authority, however, एक partner ने wrongful act करा है, then the injury caused to be associates can take action against P the partner. अब इस केस में क्या होगा बेटा, एक partner ने अगर wrongful act करा है, तो अब हम कहेंगे कि वो पर्टिकुलर पार्टनर ही लायबल है. बट अगर फर्म पूरी लायबल हो भी जाती है बिकॉज सेक्शन 25 एंड 26 के एप्लीकेबिलिटी से, क्योंकि ऑर्डिनरी कोर्स में करा है एंड विद द अथॉरिटी करा, बट वो पी से ये सारा पैसा रिकवर कर सकते. इज दैट क्लियर? So you must go through all the suggested answers, MTPs, RTPs also once, so that everything is completely done. So I wish you all the very best, students. I hope you have enjoyed my classes and you have nicely understood Sale of Goods and Indian Partnership Act. And I wish all of you all the very best. May all of you get pass and get good marks in law exam also and other papers also. Study well, all right? Okay, students, goodbye. Thank you so much. Yes, sir, we are done with the session. Thank you, students. Thank you, everyone. All right. Thank you, Sri Krishna. Thank you so much for lovely words. And do fill your feedback forms also. I wish Tanisha, but I'm not sure about that. Yes, Sarla Devi.
Madam, thank you very much for your guidance and support. Your support and guidance is wonderful. You really learn a lot of things from you. Personally, I really thanks to you, ma'am, for your kind support
Thank
at
you
this
so
point of time.
much. Sarla, today I was very unwell, and listening this from you as a feedback has really made me feel so relaxed and happy. Thank you so much.
We really miss you, ma'am. We really miss you, your classes.
Thank you, Beta. Thank you so much. Waiting to see you all soon back again.
Thank
Maybe
you,
in the
ma'am.
webinars. All
Sure.
right. All right. Yes, Arjun.
Yes, ma'am. I will miss you a lot. I will miss your classes, lectures, as well as each and as both these two chapters, also Sales of Goods Act and this Partnership Act, were nicely explained by you, and each and every sections was nicely explained by you. I had many doubts. You have cleared my doubts
Thank you, Beta.
in each and every classes. So
Thank
I will miss you a lot. I hope so that you will be in CA inter level for company law
Yes, Beta. I also
or
look forward to
corporate
meet
law.
all of
I
you.
hope I hope that you will be that I will see you soon in the inter
Yes,
level, na.
definitely.
And
I
I
will be
and I
there for you.
also miss Sudeep sir's class for contract act, and I will be meeting him for on Sunday on this Friday only for
Yes,
the LLP act. So I will
definitely.
say tell my words to him also. That's
Yes.
the same
Thank
like
you,
you.
Beta. It's your love and
Thank you.
motivation that encourages all us teachers to give our best to all of you. Thank you
Yes,
so
ma'am.
much.
And Megha ma'am and also Megha ma'am's proper guidance and how to write a case study based answer and a simple direct question answer. I have taken the tips, so I will follow each and every tips and give my best in my exam.
Yes,
Follow.
we really want that you all make us feel so proud of us and you give good exams and get clear.
Yes, ma'am.
All right.
Thank you,
Thank you
ma'am.
so much. All right. Thank you so much. Thank you, students. Thank you so much. And I really wish you all get past jaldi jaldi se CA ban jao and see you soon in CA intermediate also. All right. Thank you. Bye bye. God bless you.
Tech support. That meeting is over.